For those of you who don't know Steve, he's currently on the faculty at Washington College of Law, AU. He's a nationally recognized expert on a variety of things, wears many hats. Principal among those things are a Mets hat is probably the most important of those things, actually, by far. But focused on constitutional law and national security law. He's co-editor-in-chief of the Just Security blog, contributing editor to Lawfare, and the senior editor of the Journal of National Security Law and Policy. And one last thing before I turn it over to Steve and let him go. Steve is actually leaving DC this summer. He's going to be teaching at the University of Texas Law School starting next year. Okay. I don't want to hear that again. But I guess I did want to say on behalf of the Constitution Project, and I know quite a few people in this building, I hope that the most significant impact of your relocation is on your frequent flyer miles coming back here and nothing else. So without further ado,
Thanks, Scott. I've already asked Southwest to add another daily flight from Austin to DC. So let me just say a big thank you both to Congressman Cohen and Congressman Scott. We have been doing this for about 10 years. I will say that the midterm update for the Supreme Court is usually not quite as interesting. It's usually just February is the time when the court has set its calendar for the whole term, so it's a good time to catch up on what the court's going to decide. And we get, 25 or 30 really earnest court watchers who come to this hearing or this briefing, and we have a good conversation. I suspect many of you wouldn't be here, but for the events of about 10 days ago. So obviously the conversation has taken a much different tenor given the passing of Justice Scalia and its implications for the court in both the short and the long term. So my goal then is to focus the formal presentation on the short-term impacts, on the major cases the Supreme Court will be hearing this term and has already heard, and on how Justice Scalia's absence may affect them. But I'm happy to say more about the longer-term impact in the Q&A if folks are interested. And in case this is your first one of these, we'd like to be pretty informal, so I'm going to talk, but if you have questions, don't wait for the end. Feel free to raise your hand at any time. I can't promise I can answer your questions, but I'm happy to try. So there we go. So before turning to specific cases, let me also say a bit more generally about the dynamics of an 8th justice court. So you probably know that if the court ties 4-4 in a case, the result is to affirm the decision below without an opinion, which is basically the same thing as if the court hadn't taken the case in the first place. Same thing as a denial certiorari, which is to say it has no precedential effect at all. But where there's reason to think that the 9th seat will be filled in the near future, I leave it to you to define the terms near and future. The court's historical practice is to hold on to the case and usually set it for re-argument at some time in the future, usually the following term. And indeed, some of the court's most famous modern decisions, cases like Brown and Roe, were both re-argued after vacancies were filled. So it's not actually that unusual, even if it seems weird in the short term, for the court to hold a bunch of cases over for next year in the theory that a vacancy might be filled, one day. So even if some of the cases that we're about to discuss don't go anywhere this term, that doesn't necessarily mean they won't be resolved by the court sooner rather than later. And that's the first caveat. One more caveat. I know 10 years ago is a long time, but if you guys remember when Chief Justice Roberts came onto the court and there was some sort of turnover when Justice Alito replaced Justice O'Connor, the court that year actually did a bunch of very strange rulings, where they found hyper-narrow, hyper-specific ways to basically make the case go away and avoid closely divided 4-4, 5-4 rulings. We also might see some of that, right, where these cases end up getting resolved on grounds we weren't expecting as a way of avoiding the possibility of a tie. So we'll see. All right, so let me turn to the cases. The court's only handed down 18 decisions so far. Until about a month ago, that was about par for the course. Because there have been no decisions in the last couple of weeks, it's now actually way behind schedule comparatively. Of the 18 handed down, I think there are only really 2 of surpassing importance. The first is a case called Montgomery versus Louisiana, which the court decided on January 25th. Montgomery was a case about whether the Supreme Court's 2012 decision in Miller versus Alabama, which held that it was unconstitutional to have a sentencing scheme where juveniles could receive life without the possibility of parole. Montgomery was about whether that applied retroactively. That is to say, to juveniles who had been convicted and sentenced before Miller was decided. Montgomery himself had actually been convicted and sentenced in the 1960s. So it was very retroactive. And the Supreme Court, in a 6-3 decision by Justice Kennedy, says yes. that Miller is retroactive, and so that's of course led to a bunch of new cases in the lower courts where juveniles who were sentenced to life without parole prior to the Miller decision are now seeking to take advantage of it. So that was on January 25th. The only other, I think, really significant decision the court handed down so far this term was January 12th in a case called Hurst versus Florida. This was a case about Florida's, if you'll forgive me, unique approach to capital sentencing and the weird role that the judge plays vis-a-vis the jury. And the court, in an 8-1 opinion by Justice Sotomayor, held that Florida's approach violated the Sixth Amendment because it gave too much power to the judge to find some of the critical facts necessary to reach a death sentence. So basically applying an earlier Supreme Court decision called Ring versus Arizona, the court said this is clearly forbidden by Ring. Only Justice Alito dissented. So the two big opinions, neither were 5-4. Otherwise, it's been pretty quiet so far. Instead, almost everything is still in the offing. And I think there are 8 particularly major cases that the court said to hear this term. If I don't talk about your favorite case, please feel free to ask about it during the Q&A. Although I can't promise that I've read up on it, but I'll do my best to make it up. Kidding, mostly. All right, so going in order of when they were argued. The first major case by argument date is a case called Evanwell versus Abbott. This was a case argued on December 8th. It's a case out of Texas, and it's a case about one person, one vote. And the question in Evanwell is whether states must use voter population or whether they can instead look to total population of a district when apportioning congressional seats, when apportioning, actually in that case it was state representative seats, but the theory would be for all district line drawing. Can you count the total population of the district, or must you only count the voter population? So the argument was, so the challenger said that you had to use voter population. And the 3-judge district court said, no, total population is okay, because that's how it's been done historically. Because of the way the case is argued, it's actually an automatic appeal to the Supreme Court. And so the question for the Supreme Court is the state of Texas and the district court correct that it's perfectly okay for states to look at total population when drawing districts? Hopefully it shouldn't be hard to figure out why looking only at voter population would create some interesting skews in states with a high population of non-voters, including immigrants who are not yet citizens, including maybe especially high numbers of children, or felons, or any number of other categories of folks who are not franchised. So that's Evanwell.
It's okay to use total population? I thought you had to use total population.
So that's the way the case was litigated. The challenger said that the challengers claimed that the Equal Protection Clause requires you to use voter population. And so all the district court said was, you don't have to use voter population, you can use total population.
Can you use voter population?
So one of the interesting questions for the Supreme Court is whether they're going to say that you can. So the oral argument was all over the place on this question. Some of the justices thought that they should just leave it up to the states to decide. Some of the justices wanted to hand down a decision that was much clearer that you have to use total population. I think we might get a fractured ruling where there's agreement that it was permissible for Texas to use total population, but disagreement as to whether they had to use total population. Which of course will then only set up the next case where a state will use voter population, and then that will be challenged. Sorry, what was that question?
It just sort of trying to wrap my head around this.
Yeah.
If you use total population in a district that has a lot of migrants that can't technically vote for that member of Congress, how does that work?
So, it's how we've done it historically. Because we use total population, because total population also includes children. Before the 19th Amendment, total population included women. Right, include people under the age of 18. So it's always been total population because the theory is that the representative is representing all of them, not just the ones who are eligible to vote. Right, and so that's how apportionment has been done basically since the founding. The modern movement has been to push toward voter population, especially in those states where there's a marked difference in how the eligible voters might feel about certain policies versus the residents in their entirety.
Okay, so but if a majority, let's say, wanted a certain candidate that couldn't vote for him, but there's only a very small group of people that vote for the opposing candidate, isn't that counterproductive to the representation of that district?
So it depends on the theory, right? Is your theory that is your theory that the district should be represented in Congress to the degree that it has eligible voters, or that it should be represented in Congress to the degree that it has people living in it who need the services Congress might provide, right? And so I think the theory is that even if you can't vote, you're entitled to representation, unless you live in DC, right? But even if you can't vote, you're entitled to representation, and so the district should be based on people who are represented, not people who are voting. That's the argument. Well, then the question becomes, so how do you count? So it would be the census. So how do you count voter population? So the lawsuit argues three different ways to do it, right? People who are registered voters, which would be the narrowest. People who are eligible voters, which would be broader but very hard to count. I think part of why the court's not going to say that that's required is because it's going to be a massive set. So I don't know how Justice Scalia's absence will impact this particularly. I suspect the court was already going to be fractured, not on the result, which is to say total population is totally fine, but on whether total population is in fact mandatory. And I think that's what we'll have to look for when the decision comes out. So that's Evanwell. That was argued December 8th. The next case argued the next day is Fisher versus by soon-to-be employer, the University of Texas at Austin. It's a big term for Texas at the Supreme Court. I got nothing past it. It's just Texas is big. Okay. So Fisher versus UT is the affirmative action case that's back to the Supreme Court for the second time. Abigail Fisher is a white woman who was denied admission to the University of Texas and challenged the UT admission policy on the ground that it unconstitutionally preferred blacks. This is the 10% plus plan that UT promulgated after and in light of the court's 2003 decision in Grutter. When this case was before the court a couple of years ago, the Supreme Court reversed the Fifth Circuit very narrowly. The Fifth Circuit had upheld the plan. The Supreme Court 7-1, with Justice Kagan recused, said the Fifth Circuit had applied the test from Grutter incorrectly. It's a very narrow decision. Joan Biskupik, who's one of the Supreme Court reporters, has widely reported the story that the reason why it was hyper-narrow is because the court was originally going to dramatically scale back race-based affirmative action and the Grutter decision, but that provoked an incredibly sharp dissent from Justice Sotomayor, and so there was a compromise reached, where it would be a very narrow decision. The fact that the case is back before the Supreme Court has led some to suggest that that compromise will not hold. And because Justice Kagan is recused, this is actually one of the cases where Justice Scalia's absence may not matter at all. Because if you are a defender of the university's affirmative action policy, you would need 5 votes to uphold the decision below to support the Fifth Circuit. Justice Kennedy has already voted against the policy once. So it's a 7-justice court without Scalia and Kagan. That probably means a 4-3 decision with Justice Kennedy joining the righties. How far they go, I think, is what remains to be seen. So,
I was just wondering, is the case where Scalia said something about race that was very controversial?
Yes.
I
Yes.
wanna,
Yeah, so Justice Scalia at the oral argument in Fisher 2, this is called Fisher 2 to Fisher 1, decided it was a good time to talk about the mismatch thesis. The oral arguments in the Supreme Court will never be the same without Justice Scalia. I think we can probably all agree on that. Fisher could be a very significant decision for the future of race-based affirmative action if the court goes far, or it could be very narrow, like the last time. If the court just finds something flawed in either the UT policy or how the Fifth Circuit interpreted it. One point that's probably relevant, if it is 4-3, there is a tradition in the court's history of treating 4-justice majority opinions as somewhat less precedential. Because even though there are a majority of the justices here in that case, it's not a majority of the overall court. So even if the court were inclined to go broader, they might not, because they know that any decision they render is going to be not as binding, not as precedential as others. So that's Fisher. Everyone doing all right? Still okay? Can I read the back? Okay, good. The case where I think Justice Scalia's departure will have the largest impact is next in our list. This is Friedrichs versus California Teachers Association, also known as the Public Sector Union case. This was argued on January 11th. If you guys have studied this issue, the Supreme Court has, over the past couple of years, been dropping a series of very increasingly unsubtle hints that there were, I should say, a majority of justices who were inclined to overrule this 1977 decision, Abood. Abood had said that it does not violate the First Amendment for public sector unions to have agency shop agreements where even people who don't necessarily want to be part of the union and want to support the union's activities can be compelled to fund at least the non-political activities of the union. Abood said that did not violate the First Amendment. The Supreme Court has since been more aggressive in interpreting the First Amendment and its limits on compelled speech. And so the theory was that the court took this case to reverse Abood and hold that agency shop arrangements in public sector unions are in fact unconstitutional. That could have had obviously very significant and substantial effects on the ability of public sector unions to do their thing. But I think there's widespread consensus among court watchers that Justice Scalia's was a necessary fifth vote for all of that to happen, that this was going to be 5-4. I don't think that the conservatives will find a fifth vote to overrule Abood among the four progressives on the court. So Friedrich strikes me as actually perhaps the strongest candidate for a 4-4 dismissal, just because there's no circuit split. There's no reason why the court should wait to see if a justice nominated by President Obama, for example, would also be inclined to overrule Abood. So if you're thinking about cases where Justice Scalia's departure has the most progressive impact, Friedrich seems to be the best example. And we'll see what happens with that. That was argued January 11th. We could know as early as this Friday, or perhaps next week, if the court is going to start making publicly noting the dispositions in some of these cases, the 4-4 dismissals or the re-arguing orders. All right, so that's Friedrich's. Everyone still good? Questions? Sir?
What was the Court of Appeals decision in that case? Will you be affirmed?
Sure. So Friedrich's actually, because this is all about this 1977 Supreme Court decision, the lower courts had no ability to overrule the Supreme Court, so the lower courts upheld the arrangements at issue. So if the case were dismissed without an opinion, that would leave the lower court decision and the Supreme Court's 1977 ruling in Abood intact, which is why I think that's the most obvious sort of Scalia impact there.
Well, one of the things that the news reports did not talk about was the fact that the union is compelled, as a matter of law, to do certain representational activities, even individual representation, just like dues-paying members, and all your dues were paying were what the union was obligated by law to provide for you.
Indeed. I mean, so this was the big fight of the oral argument. Justice Alito referred repeatedly to the free riding problem. But I think there's reasonable debate about whether it really is free riding, since even the less enthusiastic members of the union are benefiting from their dues. I mean, their dues are being used to their benefit, even if it's not necessarily how they would spend the money. So it's not that so they actually are getting something for their money. It may just not be what they wanted. So that's the question. I think without Justice Scalia's vote, Abood is going to be around for a little while longer. All right, so that's third on our list. Fourth, a good old-fashioned separation of powers case, perhaps the best separation of powers case of the term. There are two, so yeah, the best separation of powers of the term is a case called Bank Markazi versus Peterson. This is about basically suits against the Iranian National Bank to collect assets of the government of Iran to satisfy judgments in civil suits arising out of terrorism. Basically, there are a series of statutes that allow for victims of terrorist acts, I should say victims of state-sponsored terrorist acts, or their families to recover against the state that is responsible. And so these plaintiffs sued under the statute. The problem is that President Obama, like President Bush and President Clinton before him, had imposed a series of blocking orders on all Iranian assets in the United States, and so the court could not get to these assets because of the blocking order. Congress, in its wisdom, in 2012, passed a statute that says, in this case and this case only, that is, they actually identified the lawsuit by the case number, those assets are available to satisfy the judgment. So basically overrode the blocking order for one case only, at which point the bank sued, arguing that such a statute was unconstitutional because it was interfering with the courts by basically telling them how to do their job in a specific case. And there's a very Delphic old Supreme Court decision called U.S. versus Klein from 1872 that seems to say Congress can't tell the courts how to do their job. And so the question in Bank Markazi is whether this statute, by compelling the court to use those assets in this case only, violates that principle and violates the separation of powers. The Solicitor General, obviously the federal government's lawyer, participated as an amicus in the case and offered a narrower reason why he did not think the statute was unconstitutional, not because it wasn't interfering with the courts, but because the case involves the immunity of a foreign sovereign, in this case Iran, and Congress historically has much greater powers over foreign sovereign immunity than it does over ordinary parties. And so perhaps Congress could, in relaxing Iran's foreign sovereign immunity, get away with stuff that it could not get away with in the normal case. I have to say, I suspect, given how the oral argument went, that the claimants are going to win, that Congress is going to win, that the bank is going to lose. And Justice Scalia might make a difference here, because I'm not sure the bank would ever have had 5 votes, but if it was going to count to 5, I have to think Justice Scalia would have been one of them, given his tendencies toward formalism in the separation of powers. Without him, I just don't see that now working out. So odds are that the claimants will be allowed to proceed, the statute will be upheld, albeit potentially on very narrow grounds. So that's Bank Markazi versus Peterson, argued January 13th. Okay, next, a case you probably heard a lot more about than the last one, Whole Woman's Health versus Hellerstedt. This is being argued next Wednesday. This is by far the most important abortion case the Supreme Court has heard in 24 years. So this is the Texas abortion case. I don't want to go into too much detail, but the long and short of it is Texas basically passed a law that requires abortion providers to have admitting privileges at a nearby hospital. I don't remember how nearby, but nearby enough. And if you guys have ever looked at a map of Texas, there are large swaths of Texas where there are no hospitals. And so as a result, just by dint of this law, there's an enormous amount of Texas that now would not be able to have any abortions because there would be no ability for a doctor to have admitting privileges at a nearby hospital. The cities would be okay, and nobody else. The Federal Appeals Court for the Fifth Circuit upheld this law, but very interestingly, the Supreme Court issued a stay of the judgment and of the law pending disposition of the cert petition. If you guys don't follow this practice, the court usually doesn't issue that kind of stay unless it's fairly clear that they're not going to follow the lower court. Right? Even if they might not follow the lower court, they're not going to issue a stay unless there's really some strong feeling that the lower court was wrong and that leaving the lower court decision intact, even while the case is in the Supreme Court, would cause harm. The court issued a stay in this case, and it was 5-4, with Justice Kennedy joining the lefties. So, if one wants to read the tea leaves there, it certainly looks like Justice Kennedy believes this law goes a bit too far, even under the more relaxed, undue burden framework of Casey, and that Justice Scalia's absence won't matter. Right? That the challengers to the law may already have 5 votes. Without Justice Scalia, at the very least, even if they don't have Justice Kennedy, that would leave the Fifth Circuit decision intact, but we probably would not see a decision somehow narrowing or further sharpening Casey, because I don't know where the 5th vote for that result would come from.
Any question about, even if you have a nearby hospital, the hospital wouldn't give you admitting privileges if you do abortions?
So there's also that. So that's the more sort of as-applied challenge to the law. So this law actually never went into effect because it was enjoined at the district court level. And so the challenge in its current form is just on its face. Just the notion that, categorically, even if in practice it's turned out to be a problem, categorically the law violates Casey. Now the argument about that is actually kind of interesting. The terrain has shifted from concerns over the health of the fetus to concerns over the health of the pregnant woman. And the question is whether that's consistent with the Casey framework, which was worried about whether the law places an undue burden on the pregnant woman's right to choose. So that's where there might have been a chance for the court to reconfigure Casey and the test. Again, without Justice Scalia, I don't know how they'd have 5 votes. And given the stay, it certainly seems like Justice Kennedy, who is no great fan of the pro-choice movement, might still think that Texas went too far in this case. So that's Whole Woman's Health versus Hellerstedt. It's going to be argued next Wednesday. Should be an interesting argument. And again, the United States is participating as an amicus on the side of the challengers to the law. So we'll see how that goes. Okay, speaking of the federal government and healthcare and contraception, actually it's a good segue. The next case on the list is Zubik versus Burwell. This is the challenge to the contraceptive coverage mandate in the ACA. New year, new ACA case. So this time around, the argument is from a bunch of religious organizations who argue that even though HHS has provided an exception and an accommodation for religious entities from the contraceptive mandate, the claim is that the accommodation is too burdensome. Basically, I don't mean to belittle it. It's a lot of paperwork and a couple of sort of additional logistical steps to take. And so the argument these groups made is even though there's an accommodation available to us, it's too burdensome, and so therefore it violates the Religious Freedom Restoration Act of 1991. This issue went to 6 different circuit courts, 5 sided with the federal government, 1, the 8th Circuit, that's the Federal Appeals Court in St. Louis, sided with the challengers, so there's a circuit split. And so the court took the case ostensibly to resolve the circuit split. Zubik is interesting in a couple of respects. The one thing about the circuit split is that it's the one case where a 4-4 affirmance would make the least sense. Because I don't think the Supreme Court is much inclined, even though they don't have both sides of the circuit split, I don't think the court's much inclined to leave the circuit split intact. And to have the law be so radically different in the 8th Circuit versus the rest of the country. So I think the question to Zubik is, are there 5 votes one way or the other? And if not, that seems to be perhaps the strongest candidate for being held over for re-argument. It's interesting, RFRA and the Religious Freedom Restoration Act was last before the court in the Hobby Lobby case. Obviously, that was a controversial 5-4 ruling, so there's no reason to think that this wouldn't also be closely divided on partisan political lines. All right, so that's the Zubik case to be argued March 23rd. The last 2 of the cases on our list haven't been scheduled yet, which means they'll both be argued in April. The first involves everyone's favorite former governor, Bob McDonnell. So McDonnell versus the United States is going to be argued in April. This is Governor McDonnell's challenge to his conviction. And what's interesting about it is actually it's a major test of the scope of federal public corruption law. So the issues in the case are whether, quote, official action, unquote, under the relevant fraud statutes requires the exercise of actual government power. Right? So in other words, is it a violation of the statute if you're basically receiving gifts and useful benefits in exchange for no specific performance of a specific governmental action, right? In exchange for just influence and access. The lower court said yes. The Supreme Court took the case to decide that question, and the question of if the statute does cover such non-governmental action is unconstitutional. So there's actually 2 pretty big questions lurking in the McDonnell case. Again, one big sign that the court is inclined to reverse the decision below is they stayed the lower court decisions pending Governor McDonnell's cert petition, which is part of why he's still free. A sign that they were inclined to reverse on one of those 2 grounds. I think it's important to note, it's not clear, again, that Justice Scalia necessarily would make a huge difference. If he would have, it probably would have been in favor of Governor McDonnell. So it might be that Justice Scalia's absence actually is a bad thing in this case for the criminal defendant. Hard to think of that being true in some of the other contexts. But this is actually, if the court doesn't just split 4-4, this could be a very important decision for future public corruption trials, and for whether you have to be able to prove that the corruption led to particular exercises of official power, or whether it's just general concerns about access and accommodations.
One of the problems with the case was I think they listed setting up meetings as an official act. You took the gifts with an expectation that you'd set up meetings, you set up meetings. The problem in this case was the guy's product didn't work. I mean, the guy was selling snake oil and the governor was helping. It just looked sleazy. But I mean, if you have the governor shilling for the Newport News shipbuilding, which makes aircraft carriers, and you set up meetings, and they've given him donations and or otherwise legal gifts, do those meetings constitute an official act that trigger bribery?
What do you think?
I think you need fair warning, because one of the members of the General Assembly says he's scared to go to the Chamber of Commerce legislative breakfast and eat the scrambled eggs because that's a gift. And they're asking you to do stuff. If you go do it, I mean, what's up with that? And campaign contributions are the same as, you give me $1,000 to my campaign, If I vote for a bill, I vote for it, and that's bribery.
Right.
Now, can I set up a meeting for a contributor?
You're asking me?
Can I meet with a contributor? You know, that it just opens up. I mean, if what people think of as courtesies become official acts, it's problematic. This is a bad case because the magnitude of the gifts, Rolex watches, I mean, it's in hundreds of thousands of dollars. It's just
Wedding.
Paid for their daughter's wedding. I mean, it's just way overboard. But the principle is, and you set up meetings. Well, the gifts were otherwise legal. And so you get to the principle in a bad case is setting up a meeting for someone that's giving you gifts, a bribe. What do you think? I think it's problematic.
So I'll look at it this way. I think the concern that this case illuminates is that the existing fraud and public corruption statutes can be read rather broadly by especially zealous prosecutors. Whether for good or for evil, I leave up to you guys. But if nothing else, I think what will happen in this case might incentivize you and your colleagues to revisit these statutes and to perhaps attempt to define with more specificity where the line is between what kinds of official actions cannot be incentivized that way and what kinds can. And frankly, I don't think that's a bad thing. I mean, right, I don't think that a Supreme Court decision interpreting a criminal statute that motivates Congress to make the statute clearer is necessarily a bad thing, even if you love or don't love Governor McDonnell. So we'll see what happens. I think the only question is whether there will be 5 justices for one result one way or the other. So I think this is a good example of why there should be some resolution of this issue now. Hopefully, Justice Scalia's departure doesn't mean that there can't be. All right, the last big case, and then there are 2 small cases, but the last big case I want to talk about is the other sort of separation of powers case of the term. This is United States versus Texas. We weren't done with Texas. This is the 4th big Texas case. And this is the challenge to President Obama's deferred action immigration policy. So you guys may know, in November of 2014, President Obama promulgated an executive order basically creating a temporary kind of parole status for parents of children lawfully admitted to the United States who are themselves out of status. And the basic gist of the program is that these individuals have a short-term promise not to be subjected to deportation proceedings and are eligible to apply for work and for driver's licenses and for all the other hallmarks of being able to sort of live a normal life, even though they don't have any kind of more permanent immigration status, since that would have to be accomplished by Congress. Texas, joined by 25 other states, sued to challenge the program on a range of grounds, the narrowest being that the policy was promulgated in violation of the procedural requirements of the Administrative Procedure Act. Basically, the government didn't do enough notice and comment rulemaking. The broadest being that, like so many other actions of the Obama administration, this is Texas, not me, the president had usurped Congress's power and was violating Article 2 of the Constitution by not taking care to see that the laws were faithfully executed. In effect, that he was going way beyond the statutes that Congress had passed. The lower courts held both that Texas and these other 25 states had standing, even though that is not at all obvious, to bring this lawsuit, and then ruled for the states on the narrowest ground, basically on the failure to comply with the APA. The government then, well, the story gets a little more interesting because there are allegations that the Fifth Circuit tried to hold this opinion for long enough so that the Supreme Court wouldn't be able to hear it while President Obama was still in office. Those are not idle allegations. Those were levied by the dissenting judge on the Fifth Circuit panel. When the case was finally decided, the Justice Department sought expedited review in the Supreme Court. Texas tried to block it. The Supreme Court said, no, we'll hear it. Texas said, we need more time for the briefing schedule. The federal government said, we'll give you 8 days. Texas said, we need 2 months. The Supreme Court said, here's 8 days. This case has political mishigas all over it. The interesting thing about the way the Supreme Court took it is when the court granted cert, the cert petition that the United States filed only raised the standing question and the APA question. So whether the plaintiffs had standing and whether the policy violated the APA, the court, when it granted cert, added back the question about the take care clause. and whether the policy, if it was otherwise lawful, was unconstitutional in violation of Article 2. That I think surprised a lot of observers. I hazard to guess that Justice Scalia may have had something to do with the addition of that question. But on the merits, I think, again, this is a case where the government may already have 5 votes. If you look at the Arizona versus U.S. case the Supreme Court decided in 2012, where the court struck down Arizona's SB 1070, it was Justice Kennedy who wrote the majority opinion explaining why not only does the federal government have so much primacy in the area of immigration regulation, but the executive branch has an awful lot of discretion by virtue of the statutes Congress has already passed. It's not obvious to me how you write an opinion that says a lot of discretion, but not this discretion. So it's quite possible that the government already had 5 votes here. But let me just say one thing. If the court is looking for a narrower way to decide this case, now that it's not a full 9-justice complement, the standing issue, I think, is very attractive. Because I think the conservatives have never been great fans of broad standing doctrine, and I think the progressives would be quite happy to hold that the states in this case didn't have standing. And so we might see consensus not on the merits of President Obama's immigration program, but on the inability of the federal courts to hear the state's challenge to it, which would have the same effect. Right, that in the short term the program would go into effect before President Obama leaves office, and then the only question would be whether someone who did have standing, and it's kind of hard to think of who that would be able to sue. So that's Texas versus the U.S., probably going to be argued the last day of the term in April.
We had a hearing on this, and it was pointed out that the appropriation from Congress to the administration to do deportations was only enough to cover a couple of percent of all the cases out there, and therefore the administration has to pick and choose.
There are 11 million people in the United States who are legally eligible for removal under current law. The federal government says it can remove at a maximum about 400,000 a year.
Okay. And then the question becomes whether or not this plan is such an abuse of discretion as to become unconstitutional?
So that's the constitutional question. The procedural question is, did the government sort of unroll this plan in a manner that didn't give people enough notice and comment? So I think that's the APA argument. So I think the APA argument is actually fairly weak because this isn't rulemaking. But that's to say, if you guys have studied administrative law, the APA's notice and comment requirements only usually apply to rulemaking. This is an executive order. Those aren't always the same thing. The constitutional argument is more interesting. I don't think it's a winner here, but I think there is an open question in the court's jurisprudence about just how far presidents can go to interpret often vague statutory delegations, and whether their discretion in such cases really is absolute. I'm not sure this is the best case for that test.
Well, the law is clear. You're supposed to do it, but you don't. The Congress did not give you enough money to do it, and therefore you must pick and choose. And when he doesn't pursue the cases that some local congressman wants pursued, I mean, is that unconstitutional?
So
you don't have enough money to do it.
Certainly not on a case-by-case basis, right? The constitutional challenge is to a categorical policy that exempts from removal of eligibility.
And that's important. You have a risk assessment, and you're only going to do the most serious cases. Is that unconstitutional? You didn't do the low risk?
So if I were on the Supreme Court, I would say no. But let me just sort of, I don't think I'm on anyone's short list. So, I wouldn't worry if I were you guys. So that's the Texas case.
No, it's not unconstitutional.
Not unconstitutional, so constitutional. I think in the areas of immigration and criminal prosecution, the executive branch has about as much discretion as we can imagine. And I actually think that's usually a pretty healthy thing. That if Congress were actually in the business of picking and choosing which cases had to be prosecuted and which immigrants had to be removed, that would get very ugly very quickly. And also, if I may, incredibly inefficient. Not that efficiency is necessarily what we're going for these days. So listen, those are the 8 big cases. Let me say one word quickly about 2 smaller cases that I actually think are super interesting, but perhaps less sort of national headline worthy, and they both involve Puerto Rico. So we don't spend a lot of time talking about the territories. There are, depending on how you count DC, there are either 5 or 6 federal territories. Some people say DC is just unique. If you mean uniquely underrepresented, maybe. Right, there's DC, Puerto Rico, the U.S. Virgin Islands, Guam, the Northern Mariana Islands, and American Samoa. Puerto Rico has always had perhaps the most unique relationship with the federal government. In 1952, Congress and President Truman authorized the people of Puerto Rico to pass their own constitution, basically to create their own sort of quasi-autonomous local government. And we're finally sort of reaping some of the consequences of that. So one case that the court has this term is called Puerto Rico versus Sanchez Valle, and the question is whether Puerto Rico is a separate sovereign for purposes of the Fifth Amendment's double jeopardy clause. So the Supreme Court has this long-standing doctrine that it doesn't violate double jeopardy when you, a criminal, are prosecuted by separate sovereigns for the same conduct. So, for example, the Commonwealth, Virginia, and the federal government could both prosecute someone who commits a crime under both Virginia and federal law, even if it's the same fact pattern, even if double jeopardy would not let Virginia try him for both, or the federal government try him for both. Is Puerto Rico a separate sovereign? Well, it's really interesting how this puts people on the wrong side of their usual arguments. So in Puerto Rico versus Sanchez Valle, these criminal defendants argued that Puerto Rico is not a separate sovereign, right, that it's the same thing as the federal government, and so their prosecutions were unconstitutional, right, so they should not have been prosecuted under Puerto Rican law. The Puerto Rican government disagreed and said, no, we actually sort of are separate sovereigns, and so we should be able to prosecute you. So the case gets to the Supreme Court in this very strange posture where Puerto Rico is saying, dear Supreme Court, we want autonomy so we can prosecute these people for the same offense that the federal government already prosecuted them for. In the process, the court is actually being asked to decide questions about Puerto Rico's autonomy that it has never had to decide, or at least not since the insular cases of the early part of the 20th century. So that should be one really interesting thing to watch. I don't think the court is about to hold that Puerto Rico is a separate sovereign in the abstract, or a wholly autonomous entity, but there was more support for the notion that, at least for double jeopardy purposes, it is really separate from the federal government because there's no control, right? Neither Congress nor President Obama tells the Puerto Rican government which cases to prosecute, nearly the same way that they do the U.S. Attorney in D.C. And so maybe the court will say for the double jeopardy clause only, territories with their own constitutions are in fact separate sovereigns from the federal government. That would be really interesting, and that would create some interesting implications going forward for territorial law. Far more important, because the money is always more important than the common law, is Puerto Rico's bankruptcy problem. So one of the weird things of federal bankruptcy law is it does not allow Puerto Rico to file for bankruptcy, even though there are mechanisms for states and other governments to take advantage of Chapter 9. Puerto Rico cannot. So Puerto Rico instead passed its own law allowing for the reorganization of lots of debts held by the public entities in Puerto Rico, which the courts then turned around and held was preempted by federal bankruptcy law's refusal to allow Puerto Rico to enjoy bankruptcy protection. So this case is not nearly as exciting as a common law perspective, but it's far more important as a matter of, I think, Puerto Rico's liquidity. And this case is called I think it's called Puerto Rico, I never remember the other title, Puerto Rico versus Franklin, California Tax-Free Trust. That's going to be argued March 22nd. And just in case I haven't completely overwhelmed you with territorial common law, also a really interesting cert petition before the court right now about whether American Samoans are entitled to birthright citizenship under the Citizenship Clause of the 14th Amendment. American Samoans are the only people today born on U.S. soil who are not citizens at birth. And so there's a question in the Supreme Court about whether that's, kind of anachronistic. If you guys haven't seen Last Week Tonight, John Oliver had a great segment on the American Samoan citizenship question. So, maybe John Oliver should be on the Supreme Court. Put a British comedian on the court. That's the answer. All right, so that's my sort of my quick and dirty view of the big cases for this term. I want to get to the Q&A, but let me just sort of say three short things about Justice Scalia's legacy and impact before we get the door open. So let me go from sort of small to big. So the first and most important thing, everyone's talking about Justice Scalia's absence and how it will impact these remaining decisions. We're thinking about how Justice Scalia's absence will impact next term. So even if we assume that through some miracle, President Obama is able to confirm a successor to Justice Scalia, let's say by October, Right? The court will have already filled half to 2/3 of its docket for the next term. That person probably wouldn't be able to start right away, would need to get caught up to speed. So next term is going to be, if you'll forgive me, a bit of a mess. I suspect we'll see a lot fewer cases granted. We'll probably see a lot of case petitions held in abeyance. And part of this is because, you guys may remember, it takes 4 votes to grant cert, but if you're the conservatives, you may not want to grant cert if you're not sure that you'd ever have a 5th vote on the merits. But that's if Justice Kennedy is the 4th vote and not the 5th vote, that calculus might change rather dramatically. To a similar degree, if you're the progressives and you're not sure about Justice Kennedy, you may not want to grant cert either. So we could see a sort of historically quiet term of the Supreme Court next year until and unless there's some sort of resolution of the vacancy.
Doesn't it depend on what the lower court was?
It might, but I think we've seen. I think it's not hard to imagine that either sort of block of justices, in cases that are likely to be political, would be far happier to leave a lower court decision they don't like intact than to risk the possibility of
refusing service.
Exactly. So defensive denials is a phenomenon that we always talk about with the Supreme Court, but with an 8-justice court and with an open seat that could be dispositive in a lot of these cases, I think you'll see a lot more of them. So next term might be an especially boring Supreme Court update.
Well, if the Supreme Court justice isn't appointed during President Obama's term, when would the next Supreme Court justice reasonably be appointed? Certainly, you've missed the first Monday in October.
Oh, by far. So if it's not President Obama, I think even optimistically, the earliest you could have a confirmed successor for Justice Scalia is the middle of March of 2017. And that's if the Senate moved quickly. And I know I'm on the House side, so I can say this. When was the last time the Senate moved quickly? And just to be clear, I mean, right, by the middle of March, the term is basically over. Right? I mean, it's the second to last argument calendar. Most of the opinions have already been assigned. So, without an, I mean, I know that I'm not one who thinks the court can't function with 8 justices, but I think we are looking at a very weird term of small decisions, compromises, and cert denials, the more it looks like there won't be a successor in place before President Obama leaves office. So that's the sort of short-term impact. Let me say sort of a bit about Justice Scalia. Justice Scalia was a polarizing figure. I mean, I think if nothing else, we can probably all agree on that. Love him or hate him, he changed the style of the Supreme Court. Oral arguments this week haven't been the same without him. There's not nearly as much sort of snarking. Maybe that's okay, maybe that's not. But his style, his wit, his irreverence would often rub people the wrong way. But I think it really did leave an impact. And so I think it's going to be remarkable to see. It's going to be interesting to see how the court changes from that perspective, how the tenor of arguments change, how the style of opinions change, how the sort of camaraderie among the justices change. Will Justice Thomas finally ask another question? Now that he no longer has someone who agrees with him on so many things to ask the questions for him. Justice Scalia's jurisprudential impact, I think, is a bit more controversial. He actually didn't end up writing that many, I think, monumental majority opinions. So often in these politically divisive cases, the opinion goes to Justice Kennedy or the Chief Justice. Scalia was rarely the dispositive vote in a common law case, unless it was the 4th or 6th Amendment, where he was actually often more felicitous of criminal defendants' rights because of his formalistic approach to those kinds of constitutional questions. His probably most important constitutional opinion is also his most controversial, his majority opinion in Heller, the 2008 Second Amendment case. Much more known for his dissents. And so I think we'll see going forward just how much of a legacy that really leaves, whether it's more his style that we remember than his actual jurisprudence. So there's that. Can I tell them what the note says? Sure. Congressman Scott just passed a note that asked if Senator Cruz is a natural-born citizen. Let me say, I believe pretty decisively the answer is yes. That my interpretation, and I think most but not all common law professors' interpretations of the natural-born citizen language of Article 2 is that the term means, are you a citizen automatically at birth? Not are you born in the United States or in the territory of the United States. There are folks who disagree with that. That's their right. They're wrong. That's not to commend the junior senator from Texas, but I think, it is to say that he can run for president if he wants to.
I understood his mother was a registered voter in Canada.
True.
Okay, well,
But so the fact that you can receive automatic citizenship at birth even if your parent is a dual citizen, right? So dual citizenship raises complications from the perspective of some statutes. It doesn't raise a complication from the perspective of automatic citizenship as long as the parent is a citizen, in good standing at the time of the child's birth. Otherwise, lots of famous people throughout American history wouldn't be U.S. citizens who we tend to think were U.S. citizens, including, among other people, Senator McCain. All right, the last thing I want to say about Justice Scalia is his successor. I don't have any great insights into who it's going to be. Sorry if you came here hoping that I knew. I will say this, I do not think it's going to be the Republican governor from Nevada, even though that is apparently today's fun rumor. But I will say this, I think whoever is the successor, whether it's someone who's appointed by President Obama or by his successor, whoever that may be, it will have an enormous impact on the court. Because the chances are it will not be someone like Justice Scalia. Even if it's a Republican, it won't be someone who is as, I think, committed at his core to the kind of originalism Justice Scalia was committed to. And if it's a Democratic appointment, I think you have not seen a single nomination to the Supreme Court that will move the court so far in one direction since 1991, so that's 25 years, when Justice Thomas was confirmed to replace Justice Marshall. So whatever you think about what's going on right now, I think part of why folks are so freaked out is because this is as important a Supreme Court appointment as there's been probably in many of your lifetimes and since I was 11. And indeed, 25 years may sound like not that long, but these appointments don't happen that often, right? This kind of sort of truly transformative appointment. Why does that matter? Well, Justice Scalia was 79. Justice Kennedy turns 80 later this year. Justice Ginsburg is already 83. Justice Breyer will turn 80 during the first term of the next presidency. And I think as Justice Scalia proves, actuarial tables are what they are. So whatever you think about what's going on right now, the next president is probably going to be able to appoint successors to both Justices Ginsburg and Kennedy, and perhaps even Justice Breyer as well, to say nothing of other folks who might leave before we expected. So even before what happened 10 days ago, this was going to be a transformative election for the Supreme Court. It may still be, depending on what happens in the Senate. So why don't I stop there and throw it open to questions and comments in the form of questions or questions in the form of comments. Yeah.
Could you briefly talk about when the precedent was set to have 9 Supreme Court?
When the precedent was set? Sure. So the short answer is 1869. I know that's what you guys are guessing. So the size of the Supreme Court actually fluctuated fairly not dramatically, but fairly consistently over the first 80 years under the Constitution. And the reason for that is actually relatively straightforward. Anyone know how many justices we had at the founding? I see 2 of my federal court students in the come on, Jason. 6, there you go. Someone pays attention to class. So the reason why we had 6, so some folks who like to talk on the news say we had 6 because the theory was you had to have a supermajority to, reverse. No, we had 6 because there were 6 circuits. And for the longest time, Congress thought that the size of the Supreme Court should be controlled by the number of circuits, and there should be 1 justice for each circuit. Because part of the justice's job until 1891 was to go out on the circuit. And so having 1 for each circuit made all kinds of sense. Congress stopped doing that in 1863 when they added a 10th seat to the Supreme Court. There actually were 10 seats for a couple of years, although they were not all ever filled. So there were never 10 justices, but there was a 10th seat. There's a trivia question to go home and tell your friends. Then what happened is President Johnson became president. If you guys know your Civil War era history, you may know that Congress, the Republican Congress and the Democratic successor to Abraham Lincoln did not exactly get along. And so to deny President Johnson the chance to fill any seat on the Supreme Court, Congress slowly peeled away seats on the court when each justice died or retired until it got to 7. And then when Grant became president, they put it back to 9. And it's been 9 ever since. Now, you may remember, or you may have studied FDR's court packing plan in the 1930s, which would have added 6 seats to the court. Fortunately, that died. So it's been 9 ever since 1869. That's a longer answer than you probably thought you were going to get. But yeah.
I wanted to talk about whole women's health
Sure.
a little bit more. You mentioned John Oliver, and he had a big show on that just last Sunday. Can you kind of explain like what actually happens if there's a 4-4 decision?
Yeah.
Like the other court's decision is going to stand?
Yeah, so in whole women's health, so let's be clear, so where we are right now is the Fifth Circuit, the federal appeals court that covers Texas, upheld the Texas law. But that decision was then stayed by the Supreme Court by a 5-4 ruling. So the law is on hold because the decision in the lower court is on hold. If the court does split 4-4 in that case, that will have the effect of affirming the Fifth Circuit decision and terminating the stay. And so the Texas law will be allowed to go into effect. That would not, however, preclude a subsequent challenge to the Texas law, whether on its face or, as Congressman Scott mentioned, on the ground that the admitting privileges are in fact not really available. And so you could bring the case back up to a full 9-justice court. Suffice to say, the lower court proceedings would go pretty quickly, since the Fifth Circuit would have already decided the issue. So that's what would happen if there were 4-4. Again, I think one can read more into the tea leaves in that case than many of the others this term, that there may already be a fifth vote on the side of the challengers, because Justice Kennedy already joined in staying the decision below. But we'll see.
Well, what happens if you're in another circuit and decide it the other way?
So, I mean, it would have, so was it, because this is a state law, it wouldn't necessarily be a circuit split unless the state law in another state was written in the exact same way as the Texas law. Now, there are other major constitutional challenges to aggressive anti-abortion laws pending. So, for example, North Dakota passed a very aggressive fetal heartbeat law that basically says you cannot have an abortion after a fetal heartbeat could be detected on a transvaginal ultrasound. I have a brand new baby, so I now understand what that means. And what that means is 6 weeks, right? That actually a transvaginal ultrasound can detect a fetal heartbeat as early as 6 weeks. Suffice it to say, plenty of women don't even know they're pregnant at 6 weeks. The North Dakota law was actually struck down by the 8th Circuit. The federal appeals court covers North Dakota, but I think there's still time if the state wants to appeal that for them to seek cert. So, this is not the only vehicle for getting aggressive anti-abortion laws to the Supreme Court. I think the reason why folks have widely viewed this as the most aggressive and important abortion case of the past 25 years is because it's the shift in focus to sort of the medical risk to the woman as justifying a burden, in this case requiring the doctor to have admitting privileges, versus how prior abortion laws were framed in these other states. And sort of a real opportunity, until Justice Scalia died anyway, for the court to either further narrow Casey, or if they got really aggressive, perhaps ditch it altogether.
So all of the justices on the Supreme Court currently, obviously, are all Yale, Harvard graduates, except for Justice Ginsburg, and they all came.
But she went to Harvard.
Yes, but she transferred, and they all came from judicial positions. What do you think, or do you have an opinion on whether the next Supreme Court justice will be coming from perhaps a political position, and do you have opinion of whether it should be that way or it should remain?
So the Supreme Court is a remarkably undiverse institution, and I don't mean that in sort of the conventional sense. If you look at where the justices went to law school, they went to 2.5 law schools. If you look at their religion, right, before Scalia passed, right, 6 Catholics and 3 Jews. That doesn't sound like a very representative cross-section of contemporary American society. They're also all from relatively, with the exception of Justice Sotomayor, from well-to-do backgrounds. I think there's a really alarming lack of experiential diversity on the current court. I think there's a really alarming lack of geographical diversity. This is a Northeast and West Coast court. Wherever you look at the term flyover states, they are not well represented on the current Supreme Court. And I think that matters. I mean, I think the reason why Congress initially had the Supreme Court divided up by circuits was not just because the justices would have to go out and ride circuit, but because that would guarantee some kind of geographical diversity. You'd have one justice from each part of the country. So I would love, in an ideal world, for the court to be diversified along any number of other axes. Before Justice Kagan was appointed, the court, for its first time in its history, was made up of justices, all of whom had been federal circuit judges before they were justices. So there's a professionalization of the Supreme Court that I think is troubling from the perspective of experiential diversity. But let me say this, I think the problem that President Obama faces is there's no opportunity here to go outside the box. Right? Even though I think the court needs some outside-the-box nominees, I think the circumstances, the timing, and the seat that President Obama is set to fill demand a very in-the-box nominee. So what I want in my next justice and what we're going to get, I think we're going to be two very, very, very different things.
Is there any chance it might not be a lawyer?
I think that would be a good thing, and I think the answer is no.
What's the experience on that?
So, I mean, there have been plenty of great justices who are not lawyers. Actually, the last justice to not even graduate from law school was Justice Jackson, who's widely viewed as one of the great, Chief Justice Roberts calls him his role model. So I guess, Chief Justice Roberts wants more non-law school graduates. Recently it's been all lawyers. But there's no reason why that has to be true. Justice O'Connor was actually largely attractive to President Reagan because of her political experience, because she had been an elected state official in Arizona. I think Justice Black, right, one of the great justices of the 20th century, came to fame as a senator from Alabama. So I think there's plenty of tradition for non-lawyers, for politicians. But I think again, President Obama is going to need someone who the Senate has already confirmed, and there aren't that many non-lawyer judges who meet that criteria. Yes, ma'am.
Yes. You were talking about John Oliver, and he did a recent, really pro-positive show on DC statehood. And pro-DC statehood people thought it was great advertising and everything. Only thing is that he gave the impression that we had to have a constitutional amendment to become a state, whereas we have legislation right now in the House, I think it's H.R. 317, and the Senate is 1688. Just simple legislation for statehood. So what's your opinion on that? Do we need a constitutional amendment or just legislation?
Wow. Okay. So here's the problem. I think the reason why this is going to sound like an awfully technical answer. I hope you'll forgive me. I think the reason why you need a constitutional amendment for DC statehood is the Senate. Right. The Constitution is pretty clear that you can't change the representation in the Senate without its own constitutional amendment or the admission of a new state. Right. So then the question is, can Congress by statute admit a new state that changes the composition of the Senate? This is why you guys need to remember back in 2009. I think,
What if the other states came in without constitutional amendment?
True, but the other states weren't specifically mentioned in the Constitution as territory expressly reserved to be the seat of government. You guys remember that Senator Hatch was a proponent of I think it was the Voting Rights Act of 2009. Basically a bill that would have given DC a voting member in the House in exchange for Utah, because if you look at who's the most underrepresented state right now, it's Utah, just because of the way the map works out. So it would have added one seat for DC and one seat for Utah. The idea being that the DC congressman would almost certainly be Democratic, and the Utah congressman wouldn't be. But that bill did not touch the Senate. Because I think the widespread understanding is you can't touch the Senate without DC becoming a state, and if you read the Constitution in a particular way, DC can't become a state without an amendment. Let me put it this way, I'm not sure if you did it by statute that anyone would have standing to challenge it.
Okay.
Right, as I say, I don't know who would be able to challenge a statute making DC a state on the ground that it injured them. So it may be one of those, constitutional questions that's like the tree in the forest. But if you just ask me as an abstract constitutional proposition, I think it probably does need an amendment. It just might be sort of unreviewable if it happened by statute. Not that I'm especially optimistic that it's going to happen by statute anytime soon.
I am.
Good. Yes, in the back.
Back to whole women's health.
Yeah.
If the law is struck down, is there any chance that anyone other than Kennedy is going to write that opinion? And is it going to? Do you think it will have any clarity?
So I think those two questions are very related. If the law is struck down, so I think there's an interesting question about the Chief Justice in whole women's health. The Chief has only been part of one major abortion case in his whole tenure on the court. That was Stenberg 2, that was Carhart 2 in 2007, and he really didn't play a major role in that case. He just sort of followed the crowd at chow time. I think there's a possibility that if the Chief takes Casey seriously, we don't know if he does, that he could keep the opinion for himself. And if he does, I think we could expect an opinion that was clearer than what we might get from Justice Kennedy. Now, I'm not sure clear is necessarily, depending on your perspective, clear may not be good or bad. I think clear might just be a very, very specific reading of Casey that serves to invalidate the Texas law, but perhaps leave open other laws that pro-choice folks might not like. So I think if it's not Kennedy, it's the chief, and if it's not the chief, it's Kennedy. And just hopefully we're all clear on the source. So the way opinion assignments work on the Supreme Court is the senior justice in the majority who assigns the opinion. Well, with Justice Scalia's passing, the senior justice after the chief is now Kennedy, which means that in any case where he's in the majority and the chief is not, he assigns the opinion, and his practice is usually in those cases to keep it. I think we could, maybe there's an outside chance that they give it to someone who's never written one of these opinions before, so like Justice Kagan, maybe, but I'd really be surprised if that happened. Yeah.
So you mentioned the Heller decision as one of Scalia's sort of landmark majorities, but I'm curious your thoughts about standing. Lujan, and in this term we have Spokio, and what the impact of the loss of Scalia will have on the standing doctrine.
Sure. So standing doctrine, in case we don't all remember our federal court classes, right? Standing is, are you the right plaintiff to bring this case? Right? Have you sued the right defendant? Can we provide the relief you sought? Right? Basically, is this really the kind of case courts are able to decide? And Justice Scalia was a leader in the sort of scaling back of standing. So you mentioned the Lujan case from 1992, where Justice Scalia not only narrowed Article III standing doctrine, but actually said Congress does not have the power to expand standing beyond what we think is its limits, which is a very big deal. But what's interesting about Lujan is even since before Justice Scalia left the court, right, Lujan had already largely been narrowed by the other important justice in the majority of Lujan, Justice Kennedy, who was always far more willing to leave some latitude for standing, if I can say this in cases where he wanted there to be standing, than Justice Scalia, who was more formalist about it. I do think Justice Scalia's departure means there probably now is not a fifth vote against standing as a general proposition in any case. And the Spokio case you mentioned, I didn't talk about this, but this is actually a really important case about standing of consumers under the Fair Credit Reporting Act that the court signed this term. There was a chance with Justice Scalia on board that the court might have invalidated the Fair Credit Reporting Act as giving too many people the power to challenge decisions by credit rating agencies that might not injure them at all. Without Justice Scalia, I don't see any way that the court invalidates that statute. And going forward, even if his successor is very, very moderate and centrist, there's no way he or she will feel nearly as strongly about narrow standing rules as Justice Scalia did. So, I think that will be an area where his legacy is not long, leaves less of an impact.
Since you mentioned standing,
Yeah.
One of the key questions that was never addressed by the court was the standing in the Fisher case.
Indeed.
And so is it possible that perhaps someone may actually just raise it just for a dispositive matter?
So this is the Supreme Court. At the time of federal court students, the first rule is everything is possible. Right? Never say never when the Supreme Court is concerned. But the standing problem in Fisher is pretty remarkable, right? That's to say, so just to describe it, so Abigail Fisher claims she was denied admission because of Texas's race-based affirmative action policy. She can't prove that, right? Maybe she was denied admission because she just, if I can say this without being rude, wasn't qualified, right? You just wouldn't have been admitted even without the affirmative action policy. So in the normal case, we would say she therefore doesn't have standing, but she can't prove that this thing is what caused her injury. The court did not seem to care at all about standing the first time the case was up. It was raised again in the briefs this time, and they again seemed not to care about standing this time. If it were a 4-4 court, I could see standing being this life raft to avoid the court blowing up on this. The problem is Justice Kagan's recusal. She's recused because she worked on this case when she was the Solicitor General. And so as a 4-3 court, I'm not sure why. It would have to be because Justice Kennedy didn't want either to say yes to the policy or no to the policy. And he's already said no once. Right? So I'm not sure why he wouldn't do it a second time. So it's possible, but I'd be really surprised if standing were to come back up in Fisher. Not that it, not because it shouldn't. Sir?
You mentioned the Heller case. My reading of that case was that the decision to create an individual right to bear arms rather than a collective militia-oriented right was actually dicta and wasn't needed to decide the case. Is it possible that that idea can be reversed? It was 5-4.
In Heller, maybe. I think the problem is the follow-on case, McDonald versus City of Chicago, which is where the court incorporates Heller against the states. And in the Chicago case, I think it actually was more central to invalidating the Chicago ordinance, to basically hold that the Second Amendment is about individual self-defense and not public self-defense. And so I think to go back on Heller, you would also have to go back on McDonald, and that might be harder for the court to swallow. But, I mean, I will say that those who think that Heller and McDonald are problematic decisions, the court since those cases has been quite circumspect about the scope of the right it articulated. So there was another case that began, I think at the end of last term, beginning of this term, I call it pregnancy brain, although, I was never pregnant and we have the baby. But there was a case out of San Francisco that both Justices Thomas and Scalia had portrayed as a direct assault, pun I think very much intended, on Heller and McDonald. And the court refused to take it, even though the Ninth Circuit had actually gone out of its way to find creative ways to uphold the San Francisco ordinance. The court has turned away every single sequel where lower courts have upheld fairly restrictive ordinances, and just won't, and over oftentimes dissents from Scalia and Thomas. So, I'm not sure that the court will have any inclination to overrule Heller and McDonald in the near future, but they may not need to if the lower courts continue to take those decisions for sort of some but not all of what they're worth, and uphold a actually potentially surprising number of local gun ordinances. And then we have a few more minutes if I haven't totally worn you guys out. Yeah?
Okay, with the Texas of the United States,
Yeah.
you mentioned they brought back the take care clause. Now, maybe I'm wrong, but I believe in, I know that we appropriate money for the removal of aliens, but I thought the law only makes them potentially removable. It doesn't actually tell the president he has to remove anyone.
So there's one category, you're basically right, there's one category of folks who are subject to what's called mandatory detention and removal. This is not about them. Right? That's a very hyper-specific, narrow category. The law does not require the president to remove anyone in particular, and the argument is not that the president must remove all of these individuals. The challenge is that Congress has not authorized the president to categorically exempt them. Right? That the president is perfectly free on a case-by-case basis to say, I decline to exercise my discretion to remove, this Blodgett guy, or Scott. But that the problem with the Deferred Action Program is its categoricalness, right? That it effectively says, we are imposing blanket, the critics will say amnesty. I think that's unfair because amnesty is only something Congress can provide. But we are imposing blanket sort of work authorization on this category of immigrants, and that's something that the challengers, the states argue, only Congress could do. This is why I don't find this argument especially compelling, because even the work authorization piece of it has not always been done by Congress. But that, I think it's more about it's not about the individual exercise of discretion. It's about taking a whole category and saying, I, the president, am saying this category of folks will not be removed.
Then you're back to the risk assessment. So this category I declare as low risk.
And the question is, right, do the current...
And I only have enough money to do the high risk.
Right, and so I think the question is, do the statutes, as they're currently worded, allow the president to make those kinds of categorical risk assessments, as opposed to individualized risk assessments?
Well, we've done it inferentially because we haven't given enough money to cover everybody.
So I think I've already betrayed my feelings on the merits of this case. So I'm probably not the right person to have this debate with. Sorry. Yeah.
This whole idea of discretion on following the law, and I'm not a lawyer, is troubling to me as a citizen because, and I realize we're talking about Congress and the President of the United States, but and it sounds like from a legal perspective there's some difference between a class discretion and an individual discretion. But for me as a citizen, I have no discretion on following the law.
True.
I either choose not to speed or speed. I have to pay my rent. If I choose not to pay my rent because I don't have enough money, Congressman, then I get put in jail. You know, there's consequences of that. Why can we do this discretion on the national level or at the ruling class level, if you accept that? Because that building over there says it's equality under the law. And if I'm going to be legal under the law or equal under the law, then I can be discretional about which laws I follow or how fast I go or whether I pay my rent or whatnot. And there should be some
Right, well, the money part is that Congress appropriated enough money to deport 400,000, there are 11 million there, so who gets deported and who doesn't?
Well,
Congress has passed the law and appropriated the money.
Well, with all due respect, Congressman, you just didn't do your job correctly.
Well, I think the question is, but then the question becomes, I think there are any number of folks, both within and without this room, who might think that Congress at various points hasn't done what we'd like them to do. The question then becomes, if Congress doesn't do what we want them to do, what results? Right? And the problem that the president faces is he literally doesn't have the resources, logistically, financially, from a personal perspective, to remove all the folks who can be removed. But forget the immigration. I mean, you mentioned speeding. Right? Do the police have to ticket you when you speed? Right? No. Maybe we prefer to live in a jurisdiction where the answer was yes. Where I wouldn't, by the way, just to be clear on that.
But
right?
some of us just get that extra treatment.
Some folks get the extra treatment for reasons that might themselves raise legal problems. But right, prosecutorial discretion is it's not just about resources, right? It's also about the notion that prosecutors and executive branch officials sometimes are in a better position to figure out which laws are more important, which laws are less important. And we just don't live in a world where all laws can be enforced at all times. We can curse that, but until we fix that, I think any executive branch official is going to be faced with the same problem. This is why I think arguments about President Obama abusing executive power ring a little hollow to me, because I think all presidents do similar things, maybe through different agencies. Right? That's to say, depending on your politics, there will be different agencies where you will be especially aggressive or shy in exercising your discretion. It's just a question of which agency you like or don't like this week. I think we could desire a different world, but the problem is in the world in which we live, where resources are finite. The president has choices, but he doesn't have the ability to do it all. It's the best I can do. Sir.
Along the same lines, how unusual is it for the Supreme Court to put a stay on an executive order?
It's like the power plan. It's not unusual for the court to stay a decision below, right? And that's sort of what's happened. That's sort of what's happened in these cases. Now, there's no stay in the Texas case, right? That's to say the president's program is on hold because the district court enjoined it. Right, and then that's just being appealed to the Supreme Court. The better example is what happened about 2 weeks ago, where the Supreme Court issued a stay of the EPA's new Clean Power Plan, even though the case hasn't even been resolved by the D.C. Circuit, the Federal Appeals Court in Washington yet. That's a little bit more unusual, not because it's the president, but because the court stayed what the executive branch was doing before the Federal Appeals Court had resolved it one way or the other. So it's not unusual at all once the case is through the appeals court. It's more unusual for the Supreme Court to jump in at that early stage. And that happened in the case of the power plan, not in the case of the immigration policy. But the power plan is another interesting example because the stay was 5-4. And without Justice Scalia, I'm hard-pressed to think who the fifth vote would be. To either stay the plan or to reverse it if and when the time comes. So it's not unusual. I think it's just newsworthy in this case because they jumped over the lower courts.
You didn't say anything about voting rights and redistricting.
True.
Could you Could you?
Sure. So there's actually, I mean, there's one. So there's what's going. There's the North Carolina case, which I can say a bit about. But there's only one really important redistricting case besides Evanwell at the court this term. This is the Harris versus the Arizona Independent Redistricting Commission. That case is another hyper technical case about vote dilution in redistricting, where I suspect, I don't want to bore you guys with the details, it's probably going to be a hyper narrow ruling about whether the Arizona Independent Commission did or did not violate the Equal Protection Clause and how they drew the district lines. It will be hyper specific, and it might even be 4-4. So I think that's not going to go anywhere. The North Carolina case is more interesting. So this was a case about the districts that North Carolina has drawn for its 2016 elections. And there was a challenge to them. I believe the lower courts upheld the maps, right? And then the question was, would the Supreme Court stay the lower court's decision or even perhaps set them aside?
I think that the lower court threw them out and required the legislature to withdraw, which they did last week.
That's right. So the new maps are in. I'm sorry, that's right. So the new maps are in. There was a new challenge to the new maps, and the Supreme Court refused to stay the new maps. The first action the Supreme Court actually took as a body after Justice Scalia's passing, which has the effect of leaving the new maps in place for both the primary and general elections in North Carolina, even though they might subsequently be invalidated by the courts. So North Carolina is going to vote under these new maps, and then the maps might get thrown out. So the reason why that's weird, the court's usual practice is to not leave new maps in place if they might subsequently be invalidated. The court's usual practice is to stick with the old maps until the new maps are clearly going to win. They violated that principle in this case, and one wonders if that's because they just, with the Justice Scalia situation, just didn't want to be bothered. The result is that these new maps drawn by the legislature will govern the primary and general elections in North Carolina, and then they might get invalidated later, and the legislature will have to go again.
Virginia's in a similar situation, and we will have arguments in a couple of days. When could we reasonably expect a decision? Would it be this year?
This is in the Fourth Circuit.
It's in the Supreme. It's out of the Fourth Circuit. Well, the Supreme Court took the case before the case was over, which was a little unusual. Right. But now they finished the process, and I guess everything's up in the Supreme Court. And the argument is in a couple of weeks, about 2 weeks, 23rd of March, and they will hear the case.
Yeah. So if they hear the case in March, they'll decide it by June. I mean, that's their practice. Okay. Right. I think the question is just whether there will be a majority given the current composition.
I think it was the Alabama case was 5-4.
True. Shelby County.
No. No, not Shelby. Shelby was the.
I'm sorry. I know what you're saying. Yeah, last year.
The Black Caucus.
Yep.
Black Caucus case, and it's a similar fact situation, and they pretty well. They sent the case back to the court, tell them read the Alabama case. If you read the Alabama case, it's what the district court did, the trial court did, and it's back up at the Supreme Court. And so it's hard to find without Scalia 5 votes to overturn it, but just in terms of timing, if they argue it in March, they did not issue a stay, which also gives you an idea what's going on. So we have a June primary. They could invalidate it theoretically right before the primary?
They could. They certainly could. They've done worse in the past. But without Justice Scalia, another possibility is that the argument, they won't, so the justices don't vote on the case until after it's been argued. And so it's possible that at the conference after it's argued, the court realizes it's 4-4. And in which case there actually be an order as early as the following Monday, dismissing the case and leaving the decision below intact.
Without an opinion.
Without an opinion. Which would at least, for the moment, create some stability for the June primary, even if it would leave the ultimate question undecided. And that's, just to sort of make this a little bit more general, that's what we're looking at, right? Not just in the voting rights context. We're looking at, the Supreme Court potentially issuing a series of either 4-4 rulings or re-argument orders that preserves the status quo in many, albeit probably not all of these cases. And then the question becomes, in cases where there's no sort of stable status quo to preserve, what does the court do? and all I can do is predict. Any more questions? Everybody good?
Well, Steve, thank you so much. This is very exciting.
And I'm happy to stick around if folks want to come ask questions, off camera. So, thanks everybody.